Macho. Great. Item number 8.
So, Chief, I appear for the respondent. I appear takes up. But if this matter was mentioned without any notice to me, and even after the fixing of the date, that also was not given. And on the 5th, and yesterday at 5 p.m., a supplementary affidavit was given to me.
We are for the petitioners. Petitioner is a state of UP Electricity Board, that is Dakshinanchal Vidyut Vitran Nigam. We are supplying power to 21 districts. There was a contract between the parties and there was a dispute arise. Contract was QR2, the supply of LED bulbs. Respondent was given an order to supply of LED bulbs. So there was, feeling aggrieved by the non-payment, there was a dispute with respect to the quality of the goods. There was an arbitral award by West Bengal State Micro and Small Facilitation Council. They have invoked MSME proceedings. Feeling aggrieved by the award, we have challenged that award under section 34. So as per section 19 of the MSME Act, there is a precursor of 75% amount deposited. So nutshell, our application is eclipsed. It is not yet heard. So what has been done, we have moved an application before the Learned Commercial Court Rajarat, where we have prayed the court that the deposit may be made by way of indemnity bond or bank guarantee or whatever. The court has allowed that application, but in that order dated 3/8/2022, the amount was not mentioned. I will address upon each issue.
So what are you likely
The order is, impugned order is dated 31/10/2025, wherein the Learned Court has ordered to deposit 40 crores as an additional amount as an interest component without considering the fact that in the arbitral award, no interest was awarded. This is a second round of litigation. First revisional application was filed by the respondent only, and your ladyship has disposed of by giving certain directions that was abided by us. We have already deposited 8 crores in that matter. So before adverting to the merits of the illegality or jurisdictional issue, I just want to address the court the chronology. So I was on order dated 3/8/2022, where the court has allowed that the deposit can be made by way of bank guarantee, your ladyship. Later on in that order, the amount was not mentioned. By the order dated 5/4/2023, the court held that because there is no amount of the interest in the award, so principal is 11.42 CR and that comes up to 8.57 crores that can be deposited by way of bank guarantee. Feeling aggrieved by the order dated 3/8/2022, respondent filed a civil revision application under 227. That application was disposed of by your ladyship only. In that order, 8 crore was directed to be deposited by way of cash and later on modified to demand draft. The question of the computation of the interest component was left open to the court. What they have done is they have misrepresented the court that Honorable High Court has directed 8 crores as an interest component and we have to deposit additional 50 crores to avail our remedy to be heard. For that matter, I would like to draw the kind attention of the court on the contents of the award. That is what, your ladyship, I will show the law. No, the thing is, I have filed an application. Court has asked both the parties to file an application for the computation of the interest component. So what has been done in the award, this is the copy of the award, the operative part is typed. The last page is the operative part of the award, your ladyship. So may I read? Award on 3/12/2019 under section 31 of the Arbitration and Conciliation Act. Whereas from the above records, it has been established that petitioner supplied part material as per the order of respondent, that is the buyer unit. The rest of the material was lying pending for the inspection, though the inspection call letter was duly served to the buyer unit. Whereas perusing the findings of the case, the claim of the petitioner is found to be true and logical. Now the main part. The buyer unit is liable to pay the total principal amount outstanding to rupees 11.42 crores plus interest thereupon 3 times the bank rate of the RBI, compounded with monthly rest. Now the catch is in the next para. The supplier unit is directed to submit their claim of interest on due amount as per the above rule to the buyer unit duly quantified and certified by the chartered accountant along with the claim of the due amount outstanding to rupees 11.42 CR. In my humble submission, your ladyship, this arbitrator has delegated the adjudication function to the chartered accountant. And this honorable court, there are 3 judgments which squarely says that arbitrator cannot delegate the adjudicatory function to the third party. That is a settled law because this is an award within the meaning of section 31. And section 31.3, when read with section 31.7, says that award interest is an inseparable part of the award. That has to be backed by the reasons and has to be awarded by the arbitrator only. Now, I will satisfy the court how this is an adjudicatory function. For that, I have to address a... No, not 34. I am only saying that what is the illegality because... Let me argue. I am addressing upon what is the illegality. Why a 40 crore? There was no interest component in the award, and despite that, the court has awarded that 75% includes the interest component. This is only my humble submission, your ladyship. For that, this is an infirmity.
The award said that we calculate 3 times of RBI benefit the award as.
There you go.
That quantify. The court did not, the arbitrator did not to ask them to give you that quantification, the calculation.
No. Unfortunately, your ladyship, the law is different because no, I will show you the judgment. Just give me a fraction of second. I will satisfy the court. The court would.
That is the point you will take in 34.
Your ladyship, but the amount I am barred by taking the 34 because till the time I will not deposit it 40 crores, I will be barred 8 crores. But there are judgments, your ladyship, which says that only if if your ladyship may have the judgments. No, I am not addressing upon. Just give me a fraction of second. I will. There are 3 judgments of this honorable court parallelly. One is Government of Maharashtra versus Shrivin Pharma. In this judgment, so the issue before the court is this is a modification application, similar case like us. Page number 6, your ladyship, para 15. Page number 6, para 15. The issue whether the petitioner award holder should put in 75% is not under challenge. The issue is whether 75% of the principal amount since interest would satisfy the rigor of section 19. So the issue before the court is whether now I will advert to what was the award contents of the award in this judgment only. For that, your ladyship may kindly have para 24 on page 10. Para 24 rate says the concluding part of the award. Buyer unit is liable to pay total principal amount outstanding to rupees so and so at the rate 3 times the bank rate of the RBI with monthly rest to the supplier unit under section 16. The supplier unit is directed to submit his claim of principal amount to the buyer unit along with the interest component on the principal amount duly quantified and certified by the chartered accountant. Now the concluding part, para 27, your ladyship. This court is of the view that delegation of an important part of adjudication process of arbitral tribunal is not permissible under the provisions of the Arbitration Act. Arbitration Act section 31 delineates the form and contents of the award and make award an inseparable part thereof. The 1996 Act does not envisage adjudication of quantum of interest in an award to be the function which can be decoupled and be delegated to another form entity and thereafter accept the determination as a part of award. Further, the impugned award in the present case depends entirely upon the calculation of the chartered accountant. Now the concluding part, para 34, your ladyship. This court is accordingly of the view that calculation of 75% under section 19 of the MSME Act would only be the amount which has been adjudicated upon and awarded by the Facilitation Council. 75% of this amount would be so and so, the council has not specified a figure for applicable interest. This has been quantified by the chartered accountant. The award debtor will deposit so and so amount before the registrar. Why I am saying is that this is an adjudicatory function, your ladyship. For that moment, I have to address upon 15, 16, 17 of the MSME Act. If your ladyship may allow, then the matter would be. Similar, there is another judgment of Hindustan Engineering, where the similar issue came up before the court, and the court has held this. Just your ladyship, it is starts from page 29. The issue before the court is what would be the 75%. In that terms only, the court has held that 75%, if the delegation would be on the, if arbitrator has, why I am saying is it is a delegation, it is, there is a difference between adjudication and computation, your ladyship. I would like to address upon MSME Act. For that matter, if you allow, I will address upon the MSME Act, what are the rights and liabilities which the arbitrator is duty bound to decide. In that light, these judgments may be appreciated. May I read the operative part, your ladyship, of this judgment? Page 30, para. The point is, when there is no part.
Lordship would kindly appreciate from the Lordship's order that MSME Act is a specific act. When MSME 17 gives me how I can recover the money, and 19 is the section through which.
Where is 19?
Lordship,
Page section.
Hmm.
Page 12.
Page 12.
Page 12, my lord.
The High Court. The matters we are on.
Justice Sarat.
16 specifies the date from which the
Lordship. Lordship.
The Lordships have read that delegating the duty to the chartered accountant to make the calculation means that interest will be paid with you. But that once that amount is not quantified, that cannot be a part of the order.
Lordship, there are judgments also there with me, if I can show. Lordship.
Copy.
Justice Bhattacharya's judgment, your Lordship, comes to AIR 2021. I'm just reading para number 8. The first part only, Lord. The head note only, Lord.
That
Lordship.
No.
what he is saying is that if the interest is quantified by 75% of that.
Lordship. And in the second judgment which I have given, Lordship V.K. Patel, Justice Bhattacharya has given out the analysis how this can be done. In second judgment. B.K. Patel. Online calculate 6617.
B.K. Patel is on execution, Your Lordship.
Lordship comes to paragraph 25 onwards, Lordship.
Hmm. I will address upon just because the issue is in all the three judgments, the V.K. Patel is on the execution proceedings, Your Lady.
You just say the law doesn't.
That is what my question. Just allow me a fraction of second. I will satisfy the court. I will not press the matter. For that matter, Your Ladyship may please have MSME Act Chapter 5, Section 15, 16, 17 are substantive provisions, Your Ladyship. Now, Section 15 would lay down liability upon the buyer and a right upon the supplier. What it says is that when there is goods, services or supply of goods and there are transactions between the buyer and supplier, there is a liability upon the buyer to pay the due amount before appointed day. So there is a catch that appointed day has to be calculated, has to be defined by the arbitrator. Now, if I'll breach Section 15, the consequence